The Supreme Court of the United States has just unleashed a judicial earthquake of such staggering magnitude that it has effectively pulverized the foundation beneath Donald Trump's feet, plunging the former president and his entire legal apparatus into a state of absolute frozen paralysis. We are currently watching a historic pivot point unfold in real time, a twist that virtually no analyst or insider predicted, and the consequences for the Trump inner circle are nothing short of terrifying. Before we dissect the intricate mechanics of this devastating legal strike and explain precisely why reports suggest Trump is spiraling into a state of genuine panic, please take a brief second to click that subscribe button, turn on your notifications, and hit the like button on this video. If you are looking for the raw, unvarnished truth about these courtroom battles, including the critical details that the mainstream legacy media often glosses over, you have found your home. Join our rapidly growing movement right now so you do not miss a single update as this extraordinary 72-hour countdown begins ticking away. Now, let us meticulously analyze the architecture of this catastrophic ruling. In a decision that constitutional scholars and legal historians are already categorizing as completely without precedent in the annals of American law, the Supreme Court has issued an order mandating that Donald Trump must immediately, without any hesitation, stalling, or delay, surrender a vast trove of financial records, internal business communications, and highly sensitive documents that even his own defense attorneys reportedly did not realize were being targeted. This was not merely a standard rejection of a minor petition or a procedural dismissal of a lower court appeal. This was the highest court in the nation violently ripping away a curtain to expose something that had been deliberately hidden. A sealed grand jury investigation has been operating in total secrecy, running on a parallel track to every other known prosecution for more than a full year. Trump is now legally forced by the Supreme Court to hand over evidence that has the potential to reveal an entirely new, previously concealed layer of criminal liability. It is genuinely difficult for us to fully grasp the reality that the Supreme Court managed to keep a legal proceeding of this colossal weight completely entirely secret for so many months. We are talking about a clandestine legal war that was fought in the shadows. It was a hidden battle that even Trump's own lead defense lawyers were reportedly unaware of until the final gavel came down. The justices released this shattering decision without a single moment of advanced warning. There were no televised oral arguments for the public to watch. There were no briefings for the media or statements to the press. There was absolutely no opportunity for Trump's massive public relations machine to try and spin the narrative, nor was there time for his legal team to draft a counterstatement. One moment, Donald Trump was operating under the belief that he possessed a complete map of the legal minefield surrounding him. He thought he had spotted every threat on the horizon. The very next moment, the floor collapsed underneath him, and he fell into a legal void that he did not even know existed. This situation is not merely about adding one more case to his ever-growing laundry list of legal tribulations. The Supreme Court has revealed that a covert investigation has been active this entire time, involving evidence so incredibly sensitive, so potentially destructive, or so vital to national security that the very existence of the subpoena itself had to remain classified. The fallout from this sudden, shocking revelation is destined to fundamentally rewrite everything we thought we understood about Trump's legal exposure and his political viability. To truly comprehend the immense gravity of this surprise ruling and understand why it has unleashed such total chaos, it is essential to understand just how extraordinarily rare this specific type of Supreme Court action actually is. Under standard operating procedures, the court stands as the ultimate symbol of transparency. Cases appear on public dockets where any citizen can track their progress. Oral arguments are put on the calendar months in advance, giving both the prosecution and the defense ample time to prepare their strategies. Legal briefs are filed openly for journalists, law professors, and the American public to scrutinize. Secrets are typically non-existent within Supreme Court proceedings. However, the court does hold the authority, in exceptionally rare and very narrowly defined scenarios, to conduct proceedings entirely under seal. This power is reserved strictly for moments when national security is in immediate danger or when other extraordinary interests demand total silence. Historically speaking, this authority has been utilized with extreme caution, generally limited to matters involving top-secret classified intelligence, active spy operations, or circumstances where public knowledge could cause immediate, irreversible damage to the United States. The very fact that the court invoked this dormant power in this specific instance speaks volumes about the extreme seriousness of the situation. According to the text of the ruling released on December 7th, this sealed process actually began more than a year ago. It originated when a grand jury issued a subpoena demanding Trump's comprehensive financial records, his internal business communications, and documents related to what the opinion vaguely refers to as matters of significant national concern. Because this subpoena was issued under seal, Trump was served with it while simultaneously being slapped with a gag order. He was legally forbidden from revealing its existence to the public, to his devoted political base, or to the media. His attorneys were handcuffed by the exact same strict confidentiality rules. Here's the plot twist that makes this entire story almost impossible to believe. Trump fought this subpoena through sealed legal filings, pushing the exact same arguments about absolute immunity and executive privilege that he has loudly shouted in public courtrooms. He leaned on his standard, familiar legal playbook, but this time, those arguments failed completely. The case moved through the federal court system entirely outside the view of the public. The lower court completely rejected his claims. The appellate court rejected them just as firmly. And now, the Supreme Court has rejected them in a final, devastating ruling that simultaneously exposes the existence of the battle and orders immediate, non-negotiable compliance. The opinion, authored by Chief Justice John Roberts, is blunt, direct, and unforgiving. It explicitly states that the subpoena seeks documents related to conduct that falls completely outside of any plausible or reasonable claim of presidential immunity. It goes on to explain that the defendant's attempts to delay, stall, and obstruct compliance have been fully exhausted through the appropriate legal channels, and that absolutely no additional delay will be permitted. Legal experts who are currently analyzing the ruling note that its specific language suggests this investigation is entirely separate from the classified documents case down in Florida, separate from the January 6th prosecution in Washington, D.C., and separate from the Georgia election interference racketeering case. This appears to be a distinct independent front, effectively a fourth major legal battlefield that opened up directly beneath Trump without the public ever realizing it was there.
It is certainly true that this is not the first time the Supreme Court has ruled against Donald Trump. He has faced defeats before. However, what makes this specific ruling fundamentally different is the element of total surprise and the revelation of this hidden dimension. When the court rejected his claims of absolute immunity earlier this year, his legal team fully anticipated that outcome. That case unfolded in the public eye. They had months to prepare alternative arguments and devise media strategies. That ruling was damaging, yes, but it was expected. When the court ruled back in 2020 that Trump's tax returns could be obtained by New York prosecutors, there was no shock involved. That legal battle had played out publicly for years, giving his attorneys plenty of time to prepare their responses and anticipate the consequences.
Even the historic Watergate decision in United States versus Nixon, which forced the president to surrender the White House tapes, followed a prolonged period of public litigation. Richard Nixon knew that case was coming, he understood exactly what was at stake, and he had time to consider his options, including his eventual resignation. This ruling is structurally different in every way. Trump's team had no awareness of this sealed proceeding at the appellate level in this specific form. They had absolutely no opportunity to prepare for this specific outcome on this specific day. They woke up and began their day believing they understood the full scope and scale of Trump's legal problems. By the middle of the day, they learned that belief was completely false. According to reporting from the New York Times on December 7th, Trump's lead attorneys actually learned of the ruling through breaking news alerts on their phones rather than through direct notification from the court. The sealed nature of the process meant that even standard procedural notices were restricted. One insider source described the atmosphere at Mar-a-Lago as utter chaos, with lawyers frantically scrambling to figure out which documents were covered by the subpoena and exactly how quickly compliance was required. This brings us to Trump's standard response pattern. When he faces setbacks, his instinct is to attack. When the immunity ruling was issued, he publicly criticized the justices. When lower courts ruled against him, he filed immediate, furious appeals. When damaging evidence surfaced in the classified documents case, he claimed it was all fabricated. His strategy has consistently been to attack the process, delay the proceedings, and delegitimize the institutions. But this ruling leaves almost no room for that approach. The subpoena has already been litigated through every single level of the federal judiciary. The Supreme Court's decision is final. There are no further appeals available. There is no higher authority to cry out to. The ruling specifies a compliance deadline of exactly 72 hours from the moment of its release. This is not a matter of weeks or months. It is a matter of 3 days. Furthermore, the court included an extraordinary warning in the text. The opinion states clearly that any failure to comply fully and in good faith will result in immediate civil and criminal contempt proceedings with penalties that could include pretrial detention. The court is effectively warning that any attempt to delay, obstruct, or provide incomplete responses could lead to actual incarceration before a trial even begins. This language reflects a judiciary that has completely exhausted its patience. The justices have watched Trump attack judges, ignore court orders, and treat the legal system like a political stage. This ruling signals, in no uncertain terms, that such behavior will no longer be tolerated.
Before we examine exactly what these documents may contain and why they are so incredibly dangerous for Trump, please take a moment to support this channel. If you value detailed analysis that digs deep to explain the real reasons behind the headlines, press that like button right now. Leave a comment sharing your own perspective on this. Do you believe Trump will actually comply, or will he attempt some form of defiance? Share this video with your friends and family members who need to understand the extreme seriousness of this moment. Engagement is the only way this vital information reaches a wider audience. So, what exactly does this sealed subpoena demand, and why has Trump's legal team descended into a crisis? The answer lies in the extraordinary breadth of the document requests. According to excerpts that were included in the now public ruling, prosecutors are seeking 3 major categories of hard evidence.
First, they are demanding complete, comprehensive financial records from Trump's business empire dating all the way back to 2015. This includes every single transaction involving foreign entities, all loan agreements and their specific terms, and all communications related to property valuations. These records directly implicate long-standing allegations regarding financial fraud and potential money laundering that have dogged Trump for years, but have never been conclusively proven in a court of law. Second, prosecutors are demanding every piece of communication between Trump and specific foreign nationals whose identities remain redacted due to serious national security concerns. This goes far beyond routine business dealings and suggests potential interactions with foreign governments or individuals linked to intelligence agencies. Analysts are speculating that this could involve anything from secret dealings with Russian oligarchs to undisclosed back-channel communications with foreign officials during or after Trump's presidency. The third category is potentially the most explosive of them all. The subpoena seeks documents related to efforts to obtain things of value from foreign sources in connection with electoral activities. This language closely mirrors federal statutes that strictly prohibit foreign contributions to United States political campaigns. This suggests that investigators may be examining whether Trump or his campaign solicited or accepted illegal foreign assistance, an allegation that strikes at the very core of democratic integrity. This is where Trump's defense team faces an almost impossible challenge. These document requests overlap with existing cases but extend far beyond them. Financial records may relate to known civil fraud matters, but they could also expose entirely new misconduct that has not yet been charged. Foreign communications may intersect with prior investigations, but the national security classification implies something far more serious is at play. Trump's attorneys have only 72 hours to gather and produce documents spanning nearly a decade of complex business and political activity. They may not even know where all the relevant materials are physically stored. They must review potentially millions of pages for privilege issues, all while knowing the court has made it crystal clear that it will accept absolutely no delays. Sources speaking to Politico on December 7th reported that Trump's legal team convened an emergency meeting within hours of the ruling to confront what one attorney described as an impossible task. The sheer volume of documents is overwhelming, the timeline is brutally short, and the penalty for failure is imprisonment. Yet the logistical challenge is only one part of the danger. The real threat lies in what these documents may actually reveal. Whatever Trump worked so aggressively to conceal through a year of secret litigation is now teetering on the brink of total exposure. The extraordinary secrecy surrounding this investigation strongly suggests that prosecutors believe the evidence is devastating. According to multiple reports, including coverage from CNN and MSNBC, Trump's reaction to the ruling was explosive. Sources describe him screaming at his attorneys, throwing objects across the room, and demanding to know who allowed this hidden proceeding to progress without stopping it. But
There was no betrayal here. His lawyers fought the subpoena and lost at every single level in proceedings they were legally barred from discussing publicly. The secrecy that Trump often uses to control narratives has turned against him. He could not rally public support for a fight that the public did not know existed.
Predictably, Trump escalated the situation almost immediately. Within hours, he posted on Truth Social attacking the Supreme Court justices, including those he personally appointed. He labeled the ruling a covert assault by corrupt judges, suggested that Chief Justice Roberts was compromised, and declared the entire proceeding unconstitutional, explicitly stating that he would not comply with what he described as an illegitimate order. Legal experts immediately raised serious concerns, warning that these statements could be used as powerful evidence demonstrating a willful intent to defy a lawful court order. If Trump follows through on his threat to refuse compliance, prosecutors can cite these very social media posts as clear proof that his non-compliance was deliberate and intentional, rather than the result of logistical difficulties or good faith disputes over the scope of the subpoena.
According to former federal prosecutor Andrew Weissman, speaking on MSNBC, Trump's public remarks amount to a written invitation for contempt proceedings. Weissman explained that when a defendant openly announces an intention to defy a Supreme Court order, prosecutors do not need to struggle to establish intent. The defendant has already admitted it to the world. This situation places Trump in a strategic box where every possible outcome leads to serious consequences. If he complies with the subpoena and turns over the documents, he provides prosecutors with evidence that could expose entirely new areas of criminal liability. Whatever he has been concealing is about to become part of the official record. If he refuses to comply, he faces immediate contempt proceedings. The court has already warned that potential sanctions could include pretrial detention.
Trump could find himself sitting in a jail cell not because of the crimes he has been charged with, but simply for refusing to obey a lawful subpoena. That would be an extraordinary spectacle, a former president imprisoned for contempt while multiple criminal trials remain pending. If he attempts to stall through procedural maneuvers, the 72-hour deadline makes that strategy nearly impossible. There is no time to file new motions. There is no time to pursue new appeals. The Supreme Court has issued its decision. The matter is closed. Compliance is mandatory. It is a trap with no escape, and it is entirely of Trump's own making. Whatever those documents contain, he could have surrendered them a year ago when the subpoena was first issued. Instead, he challenged it at every level and lost each time, wasting time and resources while the evidence remained out of prosecutors' reach. Now, he has no viable options remaining. This entire situation is sending shockwaves through Trump's political and legal circles because the disclosure of this secret proceeding raises alarming questions about what else might be unfolding behind the scenes. According to reporting from The Washington Post on December 7th, Trump's allies are in a state of near panic, attempting to determine whether there are other sealed proceedings of which they are unaware. If one confidential investigation could reach the Supreme Court without public knowledge, why could others not exist as well? What additional matters might the Department of Justice be pursuing that have not yet been revealed? This uncertainty is psychologically devastating to Trump's defense strategy. For months, his attorneys have structured their plans around the cases they believed were known: classified documents, January 6th, Georgia, and New York. They allocated resources, crafted strategies, and coordinated timelines under the assumption that they understood the full extent of Trump's legal exposure. They now realize that assumption was dangerously incomplete. The situation grew even more chaotic when reports emerged that at least 2 attorneys on Trump's legal team are considering withdrawing from the case entirely. According to sources who spoke with CNN, these lawyers were not fully informed about the sealed proceeding due to strict confidentiality requirements. They are now questioning whether they can ethically continue representing a client who may have withheld critical information from them or placed them at risk of ethical violations. Attorney withdrawal at this stage would be disastrous. New counsel would require months to familiarize themselves with the case, and the 72-hour compliance deadline does not pause for staffing changes. Trump's already damaged standing within the legal community also means that finding qualified replacements would be extremely difficult. Meanwhile, the attorney who previously cooperated with prosecutors, the individual who provided the leaked audio recordings, is reportedly offering additional context regarding the sealed subpoena. According to sources familiar with the matter cited by Politico, this cooperating witness has specific knowledge of documents Trump attempted to conceal and can testify about conversations in which Trump discussed the consequences if those records were ever made public. If this information is accurate, it means prosecutors possess more than just subpoena authority. They have a detailed roadmap. They know precisely what to search for. They can compare what Trump ultimately produces with what the cooperating witness states should exist. Any missing materials or suspicious gaps will be immediately obvious.
This leads us to a broader question about what the surprise ruling means for Trump's actual legal exposure, because its implications extend into areas that have not been publicly explored until now. First, the demand for extensive financial records suggests prosecutors are constructing a case that goes far beyond the existing fraud allegations. The New York civil fraud case focused on inflated property valuations for loan and tax purposes. However, the scope of this subpoena, reaching back to 2015 and covering all foreign transactions, indicates a deeper line of inquiry. Legal analysts are speculating about potential money laundering, unreported foreign income, or violations of the Foreign Corrupt Practices Act. According to tax law experts who spoke with CBS News, the breadth of the financial records request is extraordinary. They noted that prosecutors usually narrow subpoenas to specific transactions or defined timeframes.
Requesting everything since 2015 involving foreign entities suggests an effort to identify patterns of systemic behavior rather than isolated acts. Second, the demand for communications with redacted foreign nationals raises the specter of counterintelligence concerns. The court's reference to national security interests as justification for keeping these names sealed is not routine language. It implies that these individuals may be linked to foreign intelligence services or could themselves be subjects of ongoing national security investigations. Some legal observers are connecting this development to long-standing questions about Trump's relationships with foreign governments, his unusual deference toward Vladimir Putin, his private meetings with foreign leaders without the presence of American officials, and his handling of classified information in discussions with foreign nationals. These issues have never been fully resolved, and this subpoena may finally produce documentary evidence capable of answering them. Third, the reference to obtaining items of value from foreign sources in connection with electoral activities suggests an investigation into campaign finance violations on a scale far beyond anything previously disclosed. Federal law strictly prohibits foreign nationals from contributing to United States political campaigns, and it also forbids campaigns from soliciting or accepting such contributions. If Trump or his campaign received foreign financial assistance, that constitutes a serious federal offense. According to campaign finance experts interviewed by MSNBC, the specific language used in the court's ruling closely mirrors the statutory prohibition itself. They emphasize that prosecutors do not choose such precise wording accidentally. It indicates they may already possess evidence of potential violations and are seeking documents to confirm or expand the case. Taken together, these three areas, financial records, foreign communications, and evidence of possible foreign campaign support, paint a picture of an investigation far more severe than Trump's existing criminal cases. This is not merely about mishandling documents or openly attempting to overturn an election. It involves potential corruption at the intersection of money, foreign influence, and American democracy itself. Legal scholars are already assessing the constitutional and historical significance of this moment. Lawrence Tribe, the prominent Harvard constitutional law professor, stated on social media that this ruling may represent the most consequential Supreme Court decision involving a former president since United States versus Nixon. He observed that although the confidential procedure represents an extraordinary measure, it appears to be justified by matters of national security that we may not fully understand for an extended period.
However, what truly captured my focus was this particular element. Conservative legal analyst Jonathan Turley, who has frequently supported Trump through media appearances, went on Fox News and acknowledged that this decision presents what he termed an existential crisis to Trump's legal circumstances. Turley emphasized that the presence of confidential proceedings indicates prosecutors possess evidence of activities sufficiently serious to warrant extraordinary secrecy measures. This represents an unfavorable development for Trump, considering that even sympathetic legal professionals cannot discover a means to reduce the negative impact. You recognize you are witnessing something momentous when the defense's typical defenders find themselves without adequate responses.
Let us examine what this unexpected court ruling signifies for the direction of American democracy. Since it addresses not merely Trump's individual legal troubles, it carries substantial consequences for how we view presidential responsibility, safeguarding the nation, and respect for legal systems.
Initially, there remains the pressing matter of what these records will disclose. Should Trump conform to the court order, legal authorities will obtain access to materials that remained concealed from general knowledge for an extensive period. Such materials could fundamentally change our perspective of Trump's time as president, his commercial operations, and his associations with international governments. It could furnish responses to concerns that have troubled the American government since 2016. However, the disclosure method will face complications. Certain information is apparently confidential or involves matters related to protecting the nation. Legal professionals may be authorized to introduce it during judicial proceedings while preventing it from being released to the general public. The general population may never access the complete picture of these records' substance.
We may have to depend on judicial determinations, formal charges, and subsequent courtroom declarations to comprehend what remained unknown.
Next, this decision creates vital established legal rules applicable to forthcoming situations concerning sitting and previous leaders. The judicial body has now clearly indicated that confidential jury discussions can arrive at the Supreme Court and generate binding judgments against previous leaders. They have shown that assertions of protected authority and presidential powers, even when battled with determination, will finally be defeated when the sought material pertains to non-presidential actions. This carries weight because upcoming leaders will understand that their deeds can be researched in confidence, that their court arguments can be settled away from public attention, and that adherence can be enforced promptly after legal choices are finished. The era of using public attention and stalling tactics as primary defensive measures is approaching its termination. Subsequently, the safeguarding national security elements of this decision generate critical inquiries regarding what our governmental security organizations understand concerning Trump that ordinary residents do not know. The presence of the confidential court sessions indicates knowledge so delicate that merely disclosing that an examination exists would generate injury. What do prosecutors possess knowledge of? What have national safety organizations uncovered? Finally, before we sign off, I need to ask you one more time to engage with this content. If you found this breakdown helpful, please subscribe, like, and share. Your interaction helps us keep bringing you the truth.